Our next panel is Global Data Flows, a new era for Israel and Europe. Under EU's GDPR, data transfer from Europe must meet strict standards of data protection. We can hear more about it next. Let's welcome our moderator, Omer Tene, Chief Knowledge Officer at the International Association of Privacy Professionals. Let's meet our expert panelist, Bruno Gencarelli, Head of International Data Flows and Protection Unit at the European Commission, Dr. Andrea Jelinek, Chairman European Data Protection Board and Head of the Austrian Data Protection Authority, Dr. Wojciech, European Data Protection Supervisor, and Limor Shmerling, Managing Director at the Israel Tech Policy Institute. Guys, the stage is yours.
Thank you. Hi to all our listeners and viewers. Good afternoon. My name is Omer Tene, and I am the Vice President and Chief Knowledge Officer of the IAPP, the International Association of Privacy Professionals. I'd like to start by thanking the Cyber Week organizers. This event is the highlight of a year's worth of activities for a lot of people, and I very much hope that next spring we can rejoin you in person and actually say straight off the bat here that we would be more than happy to welcome the speakers today in Tel Aviv in the flesh next year or whenever they can come to visit. I am moderating this session on global data flows, a new era for Israel and Europe. And I'll start by introducing our speakers. We have Bruno Gencarelli, who is the head of the International Data Flows and Data Protection Unit at the European Commission. I have to say that Bruno heads the EU-UK Brexit negotiations on law enforcement and justice cooperation, and he was pulled into an urgent meeting just before recording this. So what we did is we pre-recorded him earlier, and we will add this to this session. In addition to Bruno, we have Dr. Andrea Jelinek. Andrea is the chairman of the European Data Protection Board and also the head of the Austrian Data Protection Authority. Hi, Andrea.
Hello to everybody.
We have Limor Shmerling Magaznik. Limor is the managing director of the Israel Tech Policy Institute in Tel Aviv. Hi, Limor.
Hi.
And Dr. Wojciech Wiewiorowski, who is the European Data Protection Supervisor coming from Brussels. Hi, Wojciech.
That's my pleasure. Regards from Brussels.
So thank you all for being with us. I will say just a couple of introductory words, some background for the session, and then we'll dive right in. So for a couple of decades now, international data transfers have been a fraught policy issue with a few previous clashes between the EU and the United States, specifically over transfer sharing of PNR, passenger name records, SWIFT system data, and a couple of more instances. But of course, the big disruption happened in 2013 with the Snowden revelations, which brought to the fore the scope and extent of government access to private sector data. The Snowden revelations led to the Schrems case in the European Court of Justice, which a couple of years ago invalidated the EU-US safe harbor arrangement, which was put in place to facilitate data transfers between the world's two largest trading blocs. And as many of you know, this last July, 3 months ago, the Schrems II case in the Court of Justice of the EU invalidated the privacy shield, which was the agreement between the two trading blocs put in place to facilitate data transfers. The case also cast a cloud over the continued use of a far more common transfer mechanism, which is used not just to transfer data from the EU to the US, but also to the rest of the world. And that is the standard contractual clauses, which we will talk about in this session. And finally, I will say that this, of course, isn't just an EU-US issue. It impacts data transfers from Europe to the rest of the world. Israel specifically is considered an adequate country under the European framework, so transfers are permitted to Israel, but that determination is being reviewed these very days and will have to be reviewed in light of the Schrems II holding. And of course, data transfers are a big issue also from Europe to other parts of the world, including countries that have a very different legal and even cultural perception of privacy and data protection. Just as a couple of examples, think of China or Russia. So with that, I'd like to start with the immediate implications of the Schrems II decision. And the Court of Justice held that standard contractual clauses are still valid. It did not invalidate the standard contractual clauses, but it also held that parties to a transfer may now need to adopt additional safeguards or supplementary measures in order to secure the data that is being transferred outside of Europe. And I'd like to start with you, Andrea, and to ask you what, in your view or the EDPB's view, those additional safeguards might be.
Hello, everybody, and thank you, Omer, for this introduction. And also thank you very much for this question. First of all, I'd like to emphasize that the EDPB is actually aware of the impact of this ruling on hundreds of thousands of third country entities and EU businesses of every size and in every sector. Therefore, we issued a FAQ questions document. I'm sure you're aware of that, shortly after the Schrems II ruling. And in addition to these FAQs, the European Data Protection Board has created a task force on September the 2nd to prepare recommendations for controllers and processors when transferring data to third countries. The EDPB is well aware that the Schrems II ruling gives controllers an important responsibility. The aim of our recommendations will be to help exporters fulfill their duty to ensure that the data transferred ensures the level of protection essentially equivalent to the guaranteed within the European Union. The recommendations will describe the steps exporters may follow in collaboration with importers to identify where supplementary measures are needed to reach an adequate level of protection. It will also mention the factors they could consider to select measures of a contractual, technical, and organizational nature that can be effective in a set third country. However, the implications of the judgment are wide-ranging and the context of data transfers to third countries very diverse, you know. Therefore, there cannot be a one-size-fits-all quick-fix solution. Each organization will need to evaluate its own data processing operations and transfers and take appropriate measures, bearing in mind the legal order of third countries. just for a first summary.
Thank you, Andrea. Maybe to follow up with you, Wojciech, given that the underlying concern here has been access of government and specifically in national security intelligence community bodies to private sector data, what plausibly could a company do to provide such additional safeguards or supplementary measures? Is there anything a private company can do to protect data from such, formidable powers?
I think the question is even broader that you said, because this is not only what the company has to provide, but also what the company shall explain to the player from the other country. Of course, Israel is the adequate country under the decision of the Commission. But if we compare the situation in Israel, we may say that the thing that you can show as the very good example of the additional measures which exist in the Israeli system and don't exist in the American system are the decisions of the judgments of the Supreme Court of Israel. And if you take into consideration the way as the Supreme Court of Israel has approached the collection of data for the COVID matters, and finding out that there is not enough legislation which would give the real oversight and the real remedies to the people, we can say that the company, the organization from Israel would always be able to say that the court system is protecting the personal data in the way as Europe would expect. Of course, I'm saying about a little bit theoretical situation, because as I said, Israel has the decision on the adequacy, which is not true with United States. What the company can do? Well, the company should definitely show how the organizational measures in this company are prepared, because how they are set up in order to show how the assessment of the motion which is sent to the company is done, how the assessment of the administrative or court or prosecutors motion which is directed to the company is done inside the organization. But that's true that the decisions over the requirements of the law enforcement authorities are always the most difficult to assess freely by any kind of organization, no matter if we think about the small and medium enterprise or we talk about the huge company. This is why we sometimes say that even the localization principles that may exist in some countries, which would say that the data has to be stored in this country or in this area, would not probably work with those countries and those law enforcement authorities that have a trans-border possibility of requiring data from the organization. So, as I said, that's not an easy thing, but it's still possible to explain that the organization inside the entity helps to, first of all, assess the motion. Secondly, to give the possible remedy to the person whose data is passed.
Andrea, let me just maybe finish off this question with a very specific issue. I think there is, of course, you set up the task force to consider and to explore what the interpretation of additional safeguards might be. And I think there's an expectation from the marketplace that encryption will be part of that toolbox. But I think the problem with encryption is that sometimes it doesn't allow the importing entity access to the data, and sometimes access is needed for various purposes, some of which are, I think, broadly considered as legitimate. So my question is, what about pseudonymization? If data is pseudonymized, that is, of course, one tool that is specifically acknowledged in the GDPR as not taking data outside of the realm of personal data. It's still considered personal data, but it's good data hygiene and a good measure of protection. Do you expect that, or in your personal view maybe, is that a measure that can be viewed as one of the supplementary measures the court is alluding to?
Omer, thanks again for this question. As we are just right into the work of the supplementary measures, as the experts in the subgroups are working on all of these issues, I think it's too premature to give you an answer right now. I think maybe it can be part of a bundle, but I don't tell you that this will be part of a solution. We will see how we go further in our working process.
Okay, that's fair. Let me shift to a related topic, which is the assessment that the court requires. Again, we're still in standard contractual clauses. The court requires the data exporter and importer to undertake some assessment of the ability of the importer to comply with the contract that protects the data based on the laws of the importing country. So, for example, if data is transferred from France to the United States or to India, the importer and the exporter will now have to figure out, does the law and regulation and the framework of the United States or India satisfy the Court of Justice requirements under the GDPR? Now, I know that Bruno and the European Commission take part in such assessments on a regular basis, including now, as I mentioned earlier, a reassessment of Israel's adequacy. Do you think that it's plausible for companies to undertake this type of comprehensive investigation of the legal system of a foreign country? And I'll turn to you, Limor, and ask you, of course, you've been part of the process of Israel's adequacy review back when you were still at the Privacy Protection Authority. Do you think that this type of review is something that companies can now undertake themselves?
Well, it would be quite obvious to say it is complicated. It's quite a tall order. As was said before, not a one-size-fits-all doesn't apply here as well. So large companies may have the capacity, but smaller ones, small businesses, definitely not so much. And I think that perhaps this calls back on governments or organizations that have governments working together at to try and assist in some way in giving that type of information to companies. Since going over all laws of many jurisdictions, for example, some Israeli companies who are service providers to tens of companies around the world, or other manufacturers of pharmaceuticals who have clinical trials, especially nowadays during the pandemic, that are encompassing many jurisdictions. Taking on such a mission of facilitating data transfers while evaluating each and every jurisdiction's surveillance laws and data, government access to data, to private sector data laws, is quite a difficult task.
Can I join it, Omer?
Of course.
Because I think I may probably say the things which are very rarely said about that. First of all, this is not new. This is not something that did not exist before the Court of Justice has said it. Actually, each and every controller transferring the data to the third country had always the duty to know what he or she is doing with the data and what he or she is doing with the resources which are talking about the people. So this is not new. What actually has been said here is the principle which exists at least from 1995, but I would even go back saying that this is what the Convention 108 is also based on. If you say that there is the third country, and if you say that there are the special rules about the transfer, well, these are the rules that the person who does the transfer, the organization who has to make the transfer, have to assess. Moreover, the second thing is that this is not something extraordinary. If you do the business in pharmaceutical industry and you want to get any part, any ingredient of the medicine or any kind of other thing that you do in your industry being imported from another country, you have to assess what's going on in this country. You don't need to assess only this ingredient, but also the way it has been prepared. If you are importing the goods or preparing your goods outside of Israel, you are required, for example, to assess how the labor law looks in the country. Otherwise, you might be under the strong scrutiny for the fact that there is a slavery work in the place where your industry is creating the products. So this is, of course, difficult and, of course, special in such a complicated system of the global transfers of data. But this is not neither new nor specific for the data transfers. The person who does the business have to assess how the business is done where the subcontractor is working.
Those are great points, Wojciech, and thank you for putting that in a broader context. When you do business in different parts of the world, know where you're doing business, and of course, this applies far beyond data protection.
The same as when you are investing the money of your clients in the banking system or financial system of the third country, you have to know not only if it's on the official list of the tax paradises, but also what are the circumstances under which the financial institutions work in this country.
I want to switch from the legal analysis to enforcement. In the FAQs that you had mentioned earlier, Andrea, the European data protection regulators clarified that there is no grace period to implement the Schrems II decision. And of course, this isn't just the European DPAs. The court itself could have, but didn't provide an implementation period. And this means that basically from the middle of July, companies can no longer rely on the privacy shield, and to the extent they rely on standard clauses or really other measures for that matter, they need to make sure that they are in line with the requirements that the Court of Justice put in place. Andrea, you mentioned that there are hundreds of thousands of companies that are transferring data abroad. Have the European regulators started to pursue companies, given that undoubtedly a lot of them are not complying or not complying yet with the requirements of the decision?
Omer, it's quite clear that we have to follow the judgments of our highest court, like you in Israel have to do it. You also have to follow the judgments, like the US are doing it with the Supreme Court. It's quite important that our fundamental right is protected by the court and by the laws and by the regulators. And we are going to follow these judgments for sure. It's quite normal in our democracies. I think it's not a question of suing anybody. We are investigating. I'm sure you know, in addition to the task force on supplementary measures, the board has created a task force to look into complaints filed in the aftermath of the Schrems II judgment. A total of 101 complaints were filed, and we have lodged and have been lodged with the EEA data protection authorities regarding the use of Google and Facebook services, which involve the transfer of personal data. The complainants are represented by the NGO NOYB and claim that Google and Facebook transfer personal data to the US, relying on the Privacy Shield, though the Privacy Shield was declared invalid, or on standard contractual clauses, and that, according to the recent CJEU judgment, the controller is unable to ensure an adequate protection of their personal data. This task force will analyze the matter and ensure a close cooperation among the members of the board. So this means there were already complaints filed since the 16th of July, and the European Data Protection Board, the members of the board, decided to establish a task force to look together into these same complaints, which were filed against different controllers in each EEA country, so that we are working even closer together than we did before on all of these issues. So you see, it's not a question of suing somebody or the company, but to look deeply into the complaints regarding the upholding of the fundamental right of data protection of the EU citizens.
Wojciech, as European Data Protection Supervisor, you are the regulator, the data protection regulator for the institutions of the European Union, which includes the Commission, of course, and others. How do you view enforcement in light of Schrems II? Of course, EU institutions use cloud providers and software as service providers, and everybody does. So what's your approach to enforcement here?
Well, our approach is, I would say, quite simple. So we have generally two ways of doing our job. The first is ex officio work, and the second is the work on complaints. If you think about the ex officio actions, of course, we were not waiting until the judgment of the council to start the witchcraft the next day. That was not what we planned. We didn't sit and wait whom we will enforce as the first ones. But we decided when we saw the judgment, when we understood the challenges that it gave to us, we started the enforcement strategy, I may say, which planned for several weeks and months the steps to be taken in order to map which kinds of transfers were so far based on the privacy shield, and which of them are based on this standard contractual clauses, and which may be also under this the tests that were set by the Court of Justice. And that's something which we will do for another, as I said, few months actually, until we will finish with all the institutions which are under our supervision. But of course, in case we will find something extraordinary important, we may start the enforcement procedures earlier. But this isn't about the ex officio. We may say that there is a kind of policy that the regulator can do. But when it comes to complaints, as Andrea said a while ago, there's no policy to be realized. There are complaints to deal with. And the regulators in most of the European countries, I guess actually in all the European countries, do not have a right to say, sorry, we are not ready for enforcement yet. Yeah, they cannot say definitely that they are giving the grace period, because there is nothing like that in the law. And they cannot say, we are sorry, but we are not ready yet. We will start it in a few months. You just have to observe the deadlines. And if you get the complaint, you have the deadline to answer this complaint, to start the investigation. So, sorry to say, but we can coordinate our work. We can try to coordinate the answers that we are giving, but there is no possibility for the data protection authorities to put any kind of postponement of the actions that are going out of the complaints that were delivered. And that's why Andrea was mentioning these 101 cases, but once again, these are not all the cases that are coming to the data protection authorities. There are many other people who are recalling this judgment, better or worse, try to complain about their situation.
So, of course, some of the cases, the judgments require a more complicated, elaborate procedure. You know, if the case is triggered, the cooperation and consistency mechanism in Article 60 of the GDPR, and certainly if it goes to the dispute resolution process in Article 65, but I think a lot of cases don't necessarily affect sort of cross-border within the EU.
Absolutely.
And are member state specific. Can we expect to see a wave of enforcement actions that apply to member state specific data transfers out of the EU?
There is no answer to your question, because it depends on the number of complaints. If you ask us, is there a policy to make the enforcement like that as a wave or avalanche or tsunami from Europe, I don't think that's the main concern of the data protection authorities at the moment. But if you think about the complaints, the answer is very simple. If you get 3 complaints, you will have few cases. If you get 300 complaints, you will have bigger number of cases. If you have 30,000 complaints, you will have tsunami. And it's impossible actually to guess. If you compare the number of the complaints in the member states, you will find out that the differences are extremely big, and they are not necessarily consistent with the number of citizens in this country. Simply, in some countries, the awareness is bigger. In some countries, the people are rather keen on the actions of the associations or the consumer protection bodies, for example. And in the other countries, people are rather believing in their own individual possibilities.
Just a quick, I want to let you also weigh in on this, Andrea. But maybe to frame it again in the simple sort of circumstances of an Austria-specific case, and I'm assuming, without knowing, that in Austria too, a lot of companies and probably also government institutions use cloud providers, use software as a service providers. just because, everyone in the world does. Should those companies and maybe government organizations fix the issue immediately or face enforcement?
Omer, I really want to underline what Wojciech said. Everything is going to depend on the numbers. Everything depends on the figures. And what are you doing as controller and data exporter? And I also want to underline what Wojciech said before. Some of the issues are not quite new and are not quite a question of data protection. It's just a question of what are you doing with your business? Are you a serious company? And what are you looking at? And you have to look into your data processing operations, and the things you are exporting, and also the things that you are importing. And when the GDPR entered into application, everybody thought that there was this saying on the world that the data protection authorities are going to be fining machines. No, and this was not true. We were always investigating, and we are investigating now too. It's not a question of immediate and quick fix solution and quick fix enforcement. You can be sure that we are investigating thoroughly, and if it's necessary to enforce, and the time is there to enforce, there will be no doubts of enforcement.
Great, Limor. This does have kind of a direct Israel angle. Of course, it has many indirect Israeli sort of implications, but the Israeli privacy protection regulations on data transfers from 2001 whitelist the European Union member states, actually any country that adhered to Council of Europe Convention 108, which Wojciech mentioned earlier, and also jurisdictions that receive data from Europe under a European adequacy arrangement for data transfers from Israel. So if you're an Israeli company, you can transfer data abroad to Europe or to countries that receive data from Europe under those same terms. A couple of weeks ago, the Israeli Privacy Protection Authority issued a statement clarifying that given the Schrems II decision, the privacy shield between, to be clear, Europe and the US can no longer be used to transfer data from Israel, again, pursuant to those same regulations. Do you have any opinion, view, analysis of this instruction from the Privacy Protection Authority? And maybe importantly, do you expect we will see enforcement actions in Israel under those data transfer regulations?
So in answer to your question, for Israel as an adequacy country, these local regulations apply to the transfer of Israeli population data onwards to abroad. And it was already said by the authority in the past that as Safe Harbor was canceled, and since Privacy Shield is a bilateral agreement between the US and the EU that does not necessarily apply to other countries, then already then the possibility of those transfers was not in existence. So this is more of a clarification by the Israeli authority than actually something that renews the status. In terms of onward transfers, while Israel is an adequacy country and companies here, many high-tech companies or other companies are giving services that entail both receiving data from the EU and then perhaps onward transferring it to other countries as part of the global data flows, then that is under the GDPR and the decisions of the Court of Justice. I haven't seen in the privacy authorities' public statements that data transfers is an issue that will be specifically targeted in the near future. I'm not aware that there is such a possibility. So I would say that it's maybe interesting to note that for the Israeli Privacy Protection Authority, there is no obligation to treat every complaint that they receive. So the Israeli privacy law doesn't mandate that all complaints be handled. So there is discretion for the authority to devise an enforcement policy and to decide on which complaints or in which situations, under which circumstances they initiate an investigation. They are doing audits, so I haven't seen any public statements by the Israeli privacy that includes specific plans to work on data transfers in their investigations. It's always, of course, a possibility and a prerogative of the authority. They are deciding on their enforcement actions according to a policy that includes quite a few criteria. So that's something that you just need to follow up and see how that unfolds.
Great. I want to focus for a moment on data transfers from Europe to Israel. And again, we mentioned that Israel is a quote unquote adequate jurisdiction under the European framework, but that adequacy determination was made prior to both of the Schrems cases, actually, and before the Snowden revelations. I think it's not, a secret that Israel itself has a very robust national security apparatus and might itself have government access issues similar in such ways to the ones that the US had and were reviewed in the Schrems case. What I'd like to ask all of you is, how do you see Israel's adequacy status? And this really applies to other countries as well. For example, a couple of the other adequate jurisdictions are in the Five Eyes, Canada and New Zealand, and some others have government access issues. Arguably, all countries in the world do. How do you see this affecting the adequacy status? And maybe specifically, what is or isn't relevant when looking at the adequacy of a third country? So to give you an example here, and I think you alluded to this earlier, Andrea, Israel used its national security agency, the Shabak, to monitor the location of citizens for contact tracing purposes. This, of course, is very comprehensive monitoring of telecommunications data, but doesn't necessarily affect the data of Europeans, except, to the extent that they visit Israel now during the pandemic. Does this even, flow into the adequacy assessment or not? So it's a pretty big question, and there was a lot there. But maybe Limor, you want to start?
Firstly, if we look at the Schrems 2 decision or criteria, I think Israel has quite a few things going for it in defending its adequacy, since there is a constitutional right to privacy, and there is judicial redress mechanisms. There is an independent, professionally independent authority that also has powers over the public sector, not only over the private sector. So he takes part in many internal governmental discussions, and also sometimes, like in the case of the agency participating in contact tracing and tracking, the authority has published contradicting opinions several times already, and this was presented and debated in open parliament discussions. And this was contradictory to the professional opinion of the other governmental bodies. So at least we're seeing that the mechanisms of oversight, of discourse, of allowing for mitigation are there. The outcome at the moment is not necessarily favorable. The results are causing quite a lot of distress to people's rights. But we see that the mechanism, the judicial mechanism, the internal governmental oversight are working. Apart from that, I would maybe also add that it's worth thinking the differences between various countries. So Israel's attributes as being a small economy that is very reliant on import of services and technical innovation and research and development as part of an international society, has to play in a playground that includes a lot of stakeholders, a lot of big forces with various interests and differences. Israel also has a situation of specific security risks that it needs to address, and that is all baked into policies and to how the systems work through parliament, government, and its independent authorities. So when looking at this and assessing this under, I think it's worth weighing all of those components in the process.
Thank you, Limor. Andrea, of course, Israel's adequacy is directly a matter for Bruno's team at the European Commission, but at some point an adequacy decision does go to the European Data Protection Board. How do you view these issues? And I think, again, they will apply more broadly than just to Israel, because some of the same matters that trouble the court with respect to the US are also shared by other countries.
Thank you for passing this question, Omer. Yes, you're right. I would have loved to say, okay, I just refer to what Bruno just said, but I went to think what he could have said. And as far as I see, the Commission is now assessing the adequacy decision. And when they have made their assessment, their evaluation, they will pass it to the EDPB, and the board is going to make an opinion on that. So I'm sure that the board will make a thorough opinion on the assessment of the Commission and about their findings. And so I can't see in the future about the assessment of the Commission, I can't tell you how the opinion of the board will look like, but the essentials will always be the same, and they are not unknown. Thanks.
Great. Wojciech, I want to maybe take a step back and look at the broader picture here. And I know that as a former academic, this is something that you always like to do. I think there is a worrying trend that we are seeing of data localization. And, of course, one response to the Schrems 2 decision might be a leaning of companies to localize data just in order to rid themselves of the additional reviews and hassles of cross-border data flows. I'm not sure that is a good result. We also see data localization laws in some countries that are not necessarily prioritizing privacy, like Russia or Turkey or some other countries around the world. I think you were there a couple of weeks ago at the OECD meeting that focused on data localization. It was convened by our Japanese colleagues from the Privacy Protection Authority there. Are you concerned at all about data localization?
That's true, that localization starts to be the answer to many of the questions which were said by the Court of Justice in the Schrems II judgment, which is not necessarily the right way. First of all, we have to remember that the notion localization may mean different things. And in Russia, it's done for absolutely different reasons than the ones which were proposed in Brazil or which were proposed at some stage in India. So data localization may mean that the data should stay in the country, while it can be also transferred outside. But the copy of that have to be of the use for the local authorities, national authorities. That's how it is made in Russia. On the other hand, localization does not answer the questions which are set in the Schrems judgment, because the entity which stores the data outside of the United States, but is an American entity, may be forced by American law to deliver this data to American authorities. And it's especially if the FISA Act is taken into consideration. So in this sense, I would say that I'm not keen on localization, but definitely I have a preference for those entities that are observing the European principles. So the observance of the European principles is more important than the very place where the data is stored. Well, each of us understands that the storage in this sense is not the best notion to be used. And let me also come back to the question which was asked a while ago about the way to assess the adequacy of Israel. This is not the role of the data protection authorities, as Andrea said, to assess at the moment the adequacy of Israel. This is to be done by the Commission, and the European Data Protection Board is giving its opinion towards this assessment. But what differs GDPR from the directive that was in force before GDPR is the fact that Article 45 says precisely what are the things to be taken into consideration. And I would like to ask all of you, please read Article 45, paragraph 2, and try to imagine how difficult it will be for the Commission to assess all these points, not only as far as Israel is concerned, but also New Zealand, also Canada, and also Switzerland, probably.
Great. So, Wojciech, like a good professor, you're leaving us with homework, and we will make sure to hand it in. These, of course, are critical issues for Israel, which is not only a high-tech hub, but also a small country that has pretty much all of its trade with the European Union, the United States, but also with China. And you shed a lot of light on some of the issues that are top of mind for the community these days. So I'd like to thank you all for joining us from Brussels, from Vienna, and from Tel Aviv. And again, I invite you to actually come to Tel Aviv when it's possible, hopefully next spring, be with us in person. So thank you all.
Thank you, Omer, for invitation. Thank you for possibility to talk about this important issue.
Thanks for the invitation. Thanks for the invitation also for meeting in Tel Aviv next year, hopefully.
So Bruno Gencarelli, head of the data flows and data protection unit at the European Commission, thanks for being with us.
Thank you, Omer, and thank you to all the organizers And for those in Israel, even if it's a bit late, Happy New Year.
The Court of Justice held that standard contractual clauses are still a valid data transfer mechanism, but that the parties to a data transfer may need to adopt additional measures, additional safeguards actually, or supplementary measures. What could those additional safeguards be in practice?
Thank you for the question. Well, if I may take a step back, the Court of Justice said two things. First, that you have to do what was already there actually in the standard contractual clauses, but maybe not everybody was focusing on that. You have to basically carry out a risk assessment of the transfer in light of all the circumstances of the transfer, the court says. And this probably includes things like nature of the data you transfer, who is the addressee of the data, to which laws that addressee is subject to, business model, role in the processing operation, and all of this. Our friends from the European Data Protection Board, and we are contributing very much to that work, are developing right now guidance, including on that notion. And it's only if that assessment leads to some issues, concerns, including in the area of government access, that indeed you can put into place, you have to put into place additional safeguards. That I can't come with you with a sort of a magic solution. It will very much depend on those circumstances of transfer, on the problem identified. Some measures could be, for instance, and looking also at some of the best practices that exist on the market of a technological measures. There's a lot which is being discussed around encryption, but it's far from being certainly the only security measures. Other are more of an organizational nature, including what do you do when you receive a request for access? Do you review it? Do you challenge it? Where if you have doubts on, for instance, it being excessive, what kind of data do you, for instance, probably the principle of data minimization can play a role here in the amount of data you provide in answering that request. In any way, those are the notions on which, and the concepts and the tools on which we're working, both, as I said, in the context of the development of guidance by the European Data Protection Board. And I know that as part of your event, you have spoken to Andrea, Jelinek, and Wojciech Wiewiorowski, but also as part of the modernization or the work on the modernization of SCCs. We are almost now finalizing, or we are finalizing. And it's very important that we want, and it's a delicate balancing, we want to keep the flexibility of the approach and the judgment, which is that indeed it's an approach that very much depends on the circumstance of the transfer. That means also that, for instance, some type of data, the likelihood that some type of data will be subject to access request is might be very limited or reduced compared to other types of data. So those aspects also have to be taken into consideration, and therefore there shouldn't be a sort of one-size-fits-all prescriptive solution on the one hand, and on the other hand, of course, we want to assist a stakeholder in their compliance efforts, and therefore provide a number of factors and a certain methodology that needs to be put in place to comply with these requirements.
Great. Bruno, I'd like to shift to the topic of adequacy. And of course, one of the reasons that we got into this cycle with the Schrems decision is that the United States does not have an adequacy decision from the European Union, specifically the Commission. Israel does. However, Israel's adequacy dates back to before the Schrems cases and prior, in fact, to the Snowden revelations, how will Israel's adequacy review proceed in light of the fact that Israel, too, like the US and other countries, has a fairly strong national security system in place?
Well, thank you also for that question, and indeed for that focus on Israel that might be of particular interest to many of our viewers. The problem is not to have a national security system. Every country, modern country around the world, has a national security system, and we, of course, are fully aware of the particular security threats that exist in Israel as in other countries. Another country we are, for instance, working with currently is Korea, South Korea, which has also some serious security situation or concerns. The question, and that's fully part of our assessment of the Israeli adequacy decision or the other existing adequacy decision, is whether there is a legal framework that provides for a number of condition, limitations, safeguards, including but not only in the area of redress, to ensure that balancing between security consideration in this case and privacy consideration on the other side, and so that we can indeed explain that the existing adequacy decisions, including the Israeli ones, fulfill the test. In terms of process, what we have certainly already made clear in June, when we published the first part of our report on the evaluation of the GDPR, is that since we knew it was public, meaning information that was in the public, that the judgment, and we had been notified that the judgment on Schrems 2 would be coming very soon, in July, we would report on that part of our GDPR review, meaning the part concerning the evaluation of the existing adequacy decision, including the Israeli ones, later, to fully take into account the judgment. That's exactly what we are doing. And we're working with Israel and other countries to get the information we need to fully evaluate the decision in light of the court requirements. I think what this decision shows is the level of scrutiny adequacy decision are subject to. That's also why we want to get it right. It might take a bit of more time, also because the depth of the analysis is quite significant, and that's why this dialogue is ongoing. But clearly, we will. Our aim is to close this as soon as possible. We hope with a positive outcome, but that will depend on whether the test is fulfilled or not.
Does the Commission investigate just the legal framework and measures that apply to data transfer to Europe, or also the domestic privacy and data protection situation? And I'll give you an example, which I gave the other panelists. Israel, as you know, has been using its National Security Agency for COVID-19 contact tracing and basically tracking the geolocation of its citizens. Would a practice like this impact adequacy at all?
Well, in an adequacy evaluation, we need to first of all assess what happens in an adequacy scenario. We have to follow the data in an adequacy scenario. That means what are the safeguards that apply once the data, since we're talking about a GDPR type of adequacy, is transferred from a commercial operator in the EU to a commercial operator in the third country, in this case Israel, and what happens if law enforcement, national security or other authorities want to access that data, which is received from Europe and held by a private entity in Israel. So that's the scenario on which we are basing our assessment. They might be indeed aspects of purely domestic aspects that are not directly relevant. At the same time, it is very difficult to divide clearly the two, because what might happen on an issue like the one you've mentioned is also very much indicative of whether how privacy is effectively enforced and complied with. What is, for instance, the role of the Data Protection Authority in advising the government when taking similar decisions. So we are also, because we have worked on similar issues in Europe, by the way, those are not issues that are limited to Israel. We are, of course, also very attentive to this type of developments.
Great, thank you, Bruno. And I will note that the Privacy Protection Agency in Israel provided a few adverse opinions to these practices for contact tracing by the National Security Agency. Bruno, thank you very much for being with us on a busy day. We greatly appreciate your time.
Thank you very much. And sorry I couldn't be longer with you. But indeed, we have, as you might have heard or read, important negotiation going on with the UK right now, and that is taking a lot of my time, including on a last-minute basis. But thank you very much for having me anyway.
Good luck with that, Bruno.
Bye-bye.